Thanks. If I would have known that you'd like the title, I would have kept the whack-a-mole part, which I actually removed. Well, thanks I also want to echo my thanks to Neva, Lily, and all the people who organize this. It's a great conference. I've had the opportunity now to come on a number of occasions. It's both great for a couple of reasons. One, I love coming to Israel and really enjoy interacting, but also because I have to say that Haifa, these conferences, whether it's been about search engines now, about social networks, there was one I was standing right here back in October talking about Facebook and privacy, and now talking about eBooks. These conferences are always ahead of their time. It seems like you can come here and know what is going to be the cutting edge issue and the thing that people are really grappling with a year or two from now, based on what Neva has organized now or a year earlier. So it's great to be able to be a participant as part of that. So we're talking about different strategies, and I want to talk about what isn't a totally failed strategy, but one that hasn't worked as well in Canada, at least, as some had hoped. And actually, when I was here back in October, I was here to talk about how great Canada had done with respect to Facebook and privacy. So now it's my chance to actually tell you, here's an example where things haven't gone as well as some people had hoped. And in a sense, it's a cautionary tale, largely on the reliance that many of us, particularly in this room, would place on the law. The notion that if we can find ways to get the law right, particularly for large-scale digitization, then that digitization will follow. And I think the Canadian experience to date is that it doesn't work quite so well, or at least quite as directly as that. So the legal recipe, in a sense, that we've heard now from a number of speakers largely includes, let's say, 4 components. One, of course, is the term of copyright. How long is this term? So when do various works enter into the public domain? To the extent to which works that particularly come from governments are readily available immediately. It's taken for granted in the United States, but in many other jurisdictions, there is still crown copyright or other licensing rules associated with those works, and so you don't have immediate access to those either for digitization purposes or to make them available. The question, again, we just heard it in the last speaker, the question of orphan works that, of course, still in the public domain, but we don't know where the rights holders are. And then, of course, fair dealing and fair use. And so if we think of that sort of on a map, we've got the works that we know that we can digitize right away, based either on being in the public domain and the copyright term being where it happens to be. Then there's that basket of works that we can't necessarily because they're orphan works, and we face a real problem in moving forward. And then we've got this issue of works we might know the author, we might need licensing, as we heard about earlier on, and then working in around that in some jurisdictions, or at least in the United States, the notion that fair use might solve some of those issues. So that, in a sense, is part of what's there. Lucy talked about the desirability of being able to digitize everything, and we want to get a licensing solution there because the librarians don't want to just deal with the public domain stuff. They want to deal with everything. I think that's, of course, true. But I think at the same time, there is so much, in a sense, low-hanging fruit, so much stuff out there that has yet to be digitized that in many ways, it would be good just to get on with the process of digitizing as much as we can without having necessarily to come up with a solution for all the various kinds of works that are out there. So in a sense, that's the legal recipe. And Canada, in many respects, ought to be a poster child for this. We ought to, I think, be able to say we're a world leader when it comes to being able to digitize our culture. I'll talk a little bit about what our legal rules look like in a sec, but we do pretty good against the benchmarks that I just set out. We have a digitization strategy that's been led by our national library called Library and Archives Canada. Canadian government has a long history of support for heritage and cultural institutions. We have a Minister of Canadian Heritage. They've got a large budget. Funding, whether for the public broadcaster, for various other institutions, for grants, is seen as an important part of Canadian heritage and culture, particularly given our close proximity to the United States and a strong desire within Canada to ensure that there's a preservation and support for Canadian heritage, lest Canadian heritage become little more than just American heritage, because the ease with which all of that culture just easily moves across the border. We've got universities, as you hear in a sec, who've in many ways been at the vanguard of much of this, and so they've of course got access to many of the works, and they've been quite willing willing to engage in digitization processes, and we're in the grand scheme of things relatively small. A country of 34 million people, that's obviously bigger than Israel, but we're not huge in the sense that at 34 million, we're not talking about this unbelievable, and we're a relatively young country, unbelievable amount of stuff if you were trying to digitize it all and create a universal Canadian library. And so the digitization strategy in Canada is now about 6 years old. Launched, as I mentioned, by our national librarian. And the one estimate actually just came out a week or so ago suggested that about 13% of text has now been digitized amongst the sorts of books and things like that. Most of that was stuff that was done, quite frankly, before the strategy, so it's not that the strategy has really enabled very much of this, and almost none of it has happened on the watch of the National Library itself. Some has, but very little. Most of it's actually happening through a couple of universities. There's been no significant funding at all, so notwithstanding increases in funding over the last number of years for any number of cultural projects, none of it has happened in the digitization space. There's been no real champions or leaders in this area. Some of the major institutions in Canada, whether the public broadcaster or our National Gallery and the like, they're virtually nowhere to be found on this issue. And most of this is actually happening from two libraries, one from the University of Alberta, the beneficiary for a number of years of very high oil prices, and Alberta happens to be an oil-producing province, and so it's a province that had quite a lot of money and was able to put money towards its public institutions, and they were in turn able to move forward with try to digitize their heritage. And the University of Toronto, which joined forces as one of the digitizing centers for the Internet Archive Canada, Brewster Kahl's initiative. So they've been doing a lot. They've got a great librarian there, Carol Moore, and they've been doing a lot of digitization, but their funding is drying up, and so some of that may stop. So you'd think we would do well, but as I say, I don't know that we've done as well as we ought to or should have. And so the question is why, because if we can at least identify what some of the problems were, it hopefully provides others with some solutions. Now, the obvious answer is money. And frankly, this is going to be the obvious answer for lots of places, and it's in some ways almost a too convenient excuse. So I don't want to spend a lot of time talking about it, but I think we do have to recognize that even with optimal legal frameworks, even with champions, this stuff costs. And I recognize that there are economic efficiencies to have stuff digitized as compared to having it on bookshelves and the costs that Michael was talking about. But that cost, whether it's in the labor side of it or gathering the various things, actually does cost a lot of money. It may well be a very worthwhile investment, but unless you've got someone willing to put forward the dollars to make it happen, it doesn't happen, even if we say there are no more legal issues sitting on the table. So part of it has certainly been the dollars. I don't think that a lot of it has had to do with the law, at least with respect to low-hanging fruit. So in Canada, our copyright term is life plus 50, which is burn compliant, but obviously shorter than what you'd find in Europe and the United States. So in a sense, we have a larger public domain. At least we've got 20 years worth of works that are in the public domain that don't enter into the public domain as quickly in other places. And so that's, I don't know if it's optimal, but it's better than it is in some places, I suppose. Our fair dealing provision, while not fair use in the United States, is about as good as you're going to get with respect to fair dealing. So our Supreme Court of Canada, that has examined fair dealing now in a number of cases, and actually is going to look at it at least 2 more this coming year, has called for a large and liberal interpretation with respect to fair dealing. We talked about this issue of user rights earlier today. In Canada, the Supreme Court of Canada has explicitly stated that the exceptions are user rights that need to be interpreted in balance with creator rights. So it's, as I sometimes say, what it means to provide more than just lip service to this notion of balance in copyright. The Supreme Court of Canada really has tried to put that into practice. And we've got the typical categories: research, private study, news reporting, criticism, and review. But if what you're engaged in is trying to digitize works, especially on the research side, you've got a fair dealing provision that we've already had a court say you can interpret this broadly. There's some pretty good arguments to be made. In fact, one of the cases that the Supreme Court is going to hear this year on fair dealing has to do with that research, with the research provision. And it's a case in which the argument is that song samples, the previews that you would listen to on iTunes, those 30-second samples, are consumer research. because consumers would listen to those 30 seconds to decide whether or not they want to purchase it. That was decided. The Copyright Board said that sounded right. So did the Federal Court of Appeal, and now it's up to the Supreme Court of Canada to uphold it. So we take a fairly broad interpretation here. You want to try to translate that kind of analysis into digitizing, and you can make a pretty reasonable case. We've had changes in the law with respect to what's called legal deposit, the need for publishers and others to deposit works directly with the library, moving towards electronic works, to accessing web-based pages, even the ability to circumvent digitally locked electronic works. So the National Librarian has the right to circumvent those locks to ensure that they can be archived and accessed on an ongoing basis. We do have an orphan work system. It doesn't scale very well if you're trying to deal with mass digitization. You've got the ability to go to our Copyright Board and seek a license from them if you've gone and made an effort to try to identify who the copyright owner happens to be. And they actually do a little bit of their own searching as well. People do use it, but not a huge amount. And frankly, if we were talking about thousands of attempts to use this, I think the board would collapse or the system would collapse. But they've at least got a system in place, but it hasn't really been used in this context. And even on Crown copyright, so we do have Crown copyright. Just recently, the government made changes with respect to the licensing of what are works that are otherwise subject to Crown copyright, saying that non-commercial uses don't require any further permission. So it's not quite a Creative Commons license, but at least it's a license that says, go ahead, we're not going to change Crown copyright, but we are going to give you the license you need. So the law's not all that bad. So although not perfect, but so where are some of the things that why have we fallen down? I want to quickly point to 4. One is the issue of leadership. And quite frankly, you need champions on all of this. And I say this with great respect to Library and Archives Canada, our national librarian. I don't know that they have provided that kind of leadership. So we had this national digitization strategy. We had a summit that sought to bring together, it was about 200 stakeholders that brought together just about anybody they could think of who might have an interest in this. And then, frankly, nothing happened. It took about 2 years to get a report. Initially, they only put the report on a CD-ROM and didn't even post it on the website, so it was available to many people who were involved. And the only real outcome is sort of a Canadian version of the Europeana initiative, which is Canadiana, very original, which is just a portal that tries to, again, bring together various digitization initiatives. And so there are some there, and it has started to get a little bit of attention, but not a whole lot. And institutionally, there's been challenges. So we've had changes in the identity of who the national librarian is. And so what might have been a priority for one is no longer the priority for another. Although I must admit that even the librarian who led the way on this issue back when this was a strategy, I don't know, was always convinced of convinced of the benefits of pursuing as many different approaches, let's say, as possible. And the hint that I got with respect to that was at that strategy summit where I actually gave one of the keynote addresses, and he came up to me to give a speaker's gift, which was the English translation of the French National Librarian's book criticizing the Google digitization program, for which he wrote the foreword in English. And so it was pretty clear he was a skeptic, certainly of the Google initiative, but a skeptic more generally, I think, of some of these issues. And more recently, it just hasn't been a priority at all. And so that is certainly a problem. There is another problem. We're all friendly, in this room and in the conference talking about these issues. But what we quickly learned was various stakeholders come with very, very different priorities and desires for outcomes. And it was clear as part of the summit. The publishers, and I think the first day, it was a 2-day summit, the first day of the summit were incredibly supportive of the prospect of digitization. And then in the second day, it became readily apparent that their vision of what digitization meant was the government would fund the digitization of their catalog so that they could turn around and go ahead and sell and commercialize those works. Now, that makes a whole lot of sense from a publisher perspective. It made less sense from a strategy that was trying to provide as much broad access as possible. The authors couldn't understand why anybody was focused on any of this public domain stuff anyway. The interest was they've got their own works. Why don't we pursue some of the collective licensing type solutions that we heard about earlier? So why prioritize with limited resources, limited time into digitizing those works, digitize my works and find ways for me to get paid? The libraries and universities were very concerned, certainly with some of the commercial opportunities. We heard that there's a large number of universities that have signed contracts with Google, including ones that only do public domain. I don't believe any of them are in Canada right now. And so the Canadian universities, by and large, have been very suspect. Or suspicious, I suppose, not only of Google, but when Microsoft was doing some of the same sorts of things as well, of joining forces in this regard. They looked at the contracts and ultimately didn't feel comfortable signing them. The cultural community looked at those budgets and feared shrinking budgets, and while they might have seen this as a terrific opportunity for cultural export, ultimately said, no, we'd rather ensure that funding goes to create works now, not necessarily towards these sorts of digitization programs. And many in the public interest community who might otherwise pursue this take very conservative approaches on the law side. So they look at that law side and see all sorts of problems. I look at it and see, hey, I think it actually works fairly well. But you take all of those stakeholders together and what you get is almost gridlock with very little really forward movement. As well, I would argue that there were institutional failures. So institutions that might otherwise provide real leadership didn't, whether that's the public broadcaster, the film board, the National Gallery, or others. A lot of that is really money. But it's also even in their basic approach with respect to public domain works. And so one of the frustrations, for example, with many of our museums and galleries has been that they are very reluctant to give up the revenues that they generate even off their public domain works. And so for many of them, they argue that they already face limited budgets, and that one of the ways they make up for that budget is the ability to digitize at times on request various works that they might have in their collection. Even if they are in the public domain, they will charge not only a fee for the digitization, which is of course perfectly reasonable, but they will charge additional copyright fees and administrative fees. When asked what is a copyright fee on a work that is in the public domain, they sometimes will try to make the argument that the actual digitization itself will create a new copyright in the public domain work, especially if it's a particularly artistic version of the digital version of, let's say, a photograph or a painting and the like. But otherwise, when they're on their more candid moments, simply acknowledge that they have come to rely on the revenues that this generates and that they're deeply reluctant, very reluctant to give up on that. And so in some ways, it's hard to come forward as a true champion for making these works available, particularly public domain works available, when your own practices are such that you're not making them necessarily available and trying to find ways to monetize. Brings us back to the larger dollar issues, but it's been a significant challenge. And finally, I'd argue, and this is in some ways I want to conclude with this by noting that I think that all of us who are interested in this need to acknowledge that there have been some international failures as well, and some of them may well be the challenge that we face with respect to cross-border licensing. There needs to be, in some ways, more work that justifies why this is a good idea, beyond the fact that we think it's a good idea. So I mean, in some ways, for many here, it may seem to be readily apparent that it is a good thing to digitize and make works as readily available as possible. But particularly in the current environment, when much of copyright policy and intellectual property more generally is driven by innovation, growth, and economic agendas, the fact that very few have, at least as far as I'm aware, tried to create some linkages between the economic benefits that accrue from these digitization programs, and if you digitize, then this can happen. Here's the kind of businesses that may build up on this. Here's the cost savings that you might have from an education perspective. Here's the cultural exports that you might benefit from. I think there's a lot of arguments that can be made. I don't know that we've done a lot of work on this, so that for those looking to make investments with cultural dollars, picking and choosing, because they necessarily have to pick and choose, the case hasn't always been made that this is a place where they ought to put dollars. And we are, of course, still, especially with fair dealing and fair use, grappling to a significant extent with how far you can extend fair dealing and fair use. And there were many, certainly, that were frustrated with the Google settlement, not with the terms per se, but with the very existence of the settlement, because the hope was that this would truly provide the test to identify just how far, at least in the United States, fair use can go. And there's value in these cases, at least to set some parameters and allow people to get on with it. From a global policy perspective, and we've heard about this already, the need, let's say, for an orphan works treaty, or the need to address limitations and exceptions, is something that I think many of us has recognized, but the the reality to date has been that it's almost been exclusively defensive when it comes to dealing with many of these issues at WIPO. The limitations and exceptions and development agenda, of course, is the notable example here, and the TVI treaty, the Treaty for the Visually Impaired, is the one now concrete example of trying to provide something forward, but it's been, for the most part, difficult to try to move forward on a global policy perspective, and would be a great desire to, I think, be a bit more aggressive. And finally, I think we need to find ways to better link all of this, not just within Europe, but on a global basis. It was striking when we heard yesterday, I think, about some of the availability of works within the the National Israeli Library, and they know the works that, in a sense, only they have, but not necessarily knowing what everybody else has and whether or not there's been duplication as between various institutions and digitization programs leads me to suspect that we do have, in a sense, almost a duplication problem when we've got scarce resources and scarce amount of time to do this, and it may well be that we're at times doing the same sorts of things in different places. And then finally, I would note the value in linking up different groups, different countries and their various digitization programs may also well come from shared access. Because one of the challenges that you face, especially if you're spending public tax dollars, is the question of why should I, if I'm going to, as a country, make this works available, and tax dollars have paid for it, why should I make it available outside of my own jurisdiction? And one of the benefits there is to say, if you've got a number of different countries engaged in this, the opportunity, in a sense, to swap, to say that I'll make everything, let's say, use the public broadcaster as an example, I'll digitize the Canadian Broadcasting Corporation's materials, make them readily available, and I'll swap it with the BBC so that everyone who has access to the BBC and has paid for that will have access to the Canadian works, will get access to the BBC. And before you know what you do is you start creating a true global access based, in a sense, on trying to share much of that access, because it becomes in everybody's interest to try to, in a sense, cross-license by virtue of the fact that everybody gains more access by entering into those sorts of sharing arrangements. So I'll stop there, only by noting that I think, as I say, that law plays an important part of this, but getting the legal rules right alone, I think, at least from a Canadian experience perspective, suggests that isn't enough to get us where I think many of us want to go. Thanks very much for your attention.
Any questions?
here, we teach IP law, and an increasing amount of the cases in our IP casebook are versus Google. And so I foresee in a short future we'll be teaching probably there are already Google IP seminars, but those will be full-fledged courses at some point. So we thank you for enriching our curriculum. But when looking, I think when we're going to ultimately teach a Google IP course, it's going to be a frustrating one in some sense, because at some points we see Google very fiercely standing tall, especially in the cases regarding hyperlinks and so forth, and really providing a public service in the way Michael discussed, providing precedent, clarifying precedent, fair use. But then in other areas, we see that Google is much more deferential, and so issues regarding, for instance, YouTube taking down user content that pretty clearly falls in the fair use group.
Within Google, who believe quite strongly in certain positions about what IP law should look like on the internet. And obviously the reason that we are involved in so many of these cases is that we are in a new industry and we're butting up against the edge of what the law has forced into effect. That being said, we are not.
Niva.
So just two quick comments and one question. The two comments relate is sort of a preview for our afternoon session. So one, Carol's presentation, and I think that you said that there is no politics for an illegal reform, right, in terms of legislation related to the to contracts. And I think that we need to bear in mind that courts could also play a role. So besides sitting with the lawyers in the negotiation table, people can also use lawyers in another way and bring this to the court. And just to give an example, there is one of the participants in our afternoon session is Judge Michal who is here with us, that held in Israel related in a case related to a license that you cannot license what you don't have. So if this is not within your intellectual property, you cannot license this, right? You cannot control this in a contract. So it's probably different, when you have a contract that is actually negotiated with another party, but it's definitely an arguable with respect to licenses, and most of these licenses are standard form licenses that are just attached to the digital content. The second point has to do with another with Michael Geist presentation, and here I think that you talked about to play a role in the sense that once you remove some of the impediments related to liability, you can use a crowd for the digitization. And I know that
Wonderful talks, and
served, I think, upstairs, right? There is a coffee place that is called Greg. We will leave the crowd.
okay, thank you very much.
We have talked about many interesting issues, and many of our concerns will become bigger or smaller depending on the amount of competition we expect to see in the markets that we have discussed. For instance, restrictions in contracts that go beyond what copyright reserves to authors, or the issue of digital rights management. Abuses, or at least transgressions in these aspects will, if there is competition, at least we might expect these to be punished on a free market base. But obviously we're dealing with intellectual property rights concerning these products, and as we know, intellectual property rights have that terrible paradox in that they stifle composition and have been designed to do that in order to preserve some gains for authors. And so what this panel will do is provide a number of reflections on the amount of competition we could reasonably expect. And we will have speakers talking about both the legal aspects, the enforcement reality of some of what we've discussed. We'll have a discussion of an example of technological prospects in terms of competition, and no other issue brings the competition aspects more to the front than the Google book search settlement, and so we'll have a number of reflections on the competitive aspects and on these issues. So we will start with Dr. Michal Agmon-Gonen, who is a federal judge at the District Court of Tel-Aviv. She will discuss with us the enforcement realities and the need for alternative business models. The floor is yours.
Good afternoon. In the 2 days of conference, I've been here today, but I saw the other lectures. You talked about many topics regarding digital books, and I want to touch on a bit wider problems. I think the problems that we are faced in the digital era are the same, or have same aspects in music, in trademarks, in books, in all the intellectual property, actually. So we're talking about question of policy regarding intellectual property rights, and I want to touch about 3 subjects. New technologies that has to face old rights, and I'm going to touch on file sharing, cropping, and streaming, IP versus unjust enrichment, and right holders versus user rights, and I'm going to end with enforcement. So I want to start with the new technologies. The digital technologies and the internet made copying very easy. We talked about it this morning. File sharing is used to download many music, movies, and as this conference goes, I think also books, and it will become more and more popular, I believe. The right owners, which is a question, who are the right owners, if we're talking about the real authors or the big industries, are suing. And I would like to ask the question, should these cases be decided in courts or in the markets and by the markets? I think the history of the music industry shows that it cannot be decided in the courts. The music industry over the last 20 years won in court almost every time, US mainly. We all know Napster, Kazaa, Grokster, all of those cases. They won in court, they lost the business. And there were more and more and more file sharing programs. When a certain practice was struck by the court, a new one came in. And until the industry began to adjust the business model to the new technology, we find iTunes, for example, or the other business models that you pay fixed sum of money, small sums of money, and get a lot of music. And the winning in court didn't get the industry almost anything. Another example is cropping. It was in Israeli courts, a few cases were adjudicated. The problem is that, and we see it in other places as well, wanted ads for jobs, for houses, for almost anything and everything. some of the sites were copied in various techniques that actually cropped the data and put it in other sites.